Hello friends, this is 17th video of the series Companies Act 2013 revision. So we are revising Companies Act 2013, and in our last 16th video we had covered section 149 relating to appointment of director, qualification of director, number of directors, women director, resident director, independent director. And now in this independent director we are covering a few more points, and then we will proceed to small shareholder director and further. So disclaimer alert that this is only for revision purpose, and we are using Saransh by Institute of Chartered Accountants of India for the purpose of revision. When independent director can have stock options. So under section 149 subsection 9, whether independent director can have stock option. So notwithstanding anything contained in any other provision of this act, but subject to provisions of section 197 and 198, an independent director shall not be entitled to any stock option and may receive remuneration by way of fees provided under section 197 subsection 5, reimbursement of expenses for participation in the board and other meetings, and profit relating to commissions as may be approved by members. So he can receive profits, he can receive reimbursement, he can receive remuneration, and for profits he requires approval of members, but he cannot get stock options. This is ideal case. However, if anything contrary is given in Companies Act, then that will prevail, provided that if a company has no profits or its profits are inadequate, an independent director may receive remuneration exclusive of any fees payable under subsection 5 of section 197 in accordance with the provisions of Schedule 5th. So in case company is not having profits, or in case company has inadequate profit, then independent director may receive remuneration exclusive fees payable under 197 subsection 5 according to provisions of schedule 5th. So we will consider schedule 5th in case of no profits or inadequate profit, and we still want to remunerate independent director. Okay. Tenure of office of independent directors. So section 149 subsection 10 and section 149 subsection 11, this relates to tenure of office of independent director. So what we are learning is that an independent director shall hold office for a term up to 5 consecutive years on the board of the company, but shall be eligible for reappointment on passing of a special resolution by the company and disclosure of such appointment in the board's report. So first, he is appointed for 5 consecutive years at one stretch. So ideally we should appoint him for 5 consecutive years at one go, at one stretch, but shall be eligible for reappointment by passing a special resolution. So at the time of reappointment of independent director, we require a special resolution, and a disclosure is to be made in the board's report. But ideally, we make all disclosures relating to changes in directors, and we will incorporate this disclosure also. No independent director shall hold office for more than 2 consecutive terms. Such such independent director shall be eligible for appointment after the expiration of 3 years of ceasing to become an independent director. So if he ceases to be an independent director, then he can be again reappointed after completing 3 years, provided that an independent director shall not, during the said period of 3 years, be appointed in or be associated with the company in any other capacity, either directly or indirectly. So that independent director shall not be associated with the company during those 3 years of cooling period. He should not be associated with the company at all. Now explanation is for the purpose of subsection 10 and 11, any tenure of independent director on the date of commencement of this act shall not be counted as a term under those subsections. So if at the time of commencement of Companies Act, if a person was already an independent director, then his prior period will not be counted for the purpose of tenure of office of independent director. So we understand that he can be appointed for 5 consecutive years, then he can be reappointed for 5 consecutive years after passing a special resolution and making a note in the board's report. And then a cooling off period of 3 years is to be given, during which he should not be associated with the company directly or indirectly. Liability of independent director, section 149, subsection 12. Now, notwithstanding anything contained in this act, independent director shall be liable in respect of following: acts of omission or commission by the company which has occurred by his knowledge. So he had knowledge of such act of commission or omission, attributable through board processes. So through board processes, he became attributable through board processes. Through board process, he become to awareness with his consent or connivance. So or where he had not acted diligently. So this has happened with his consent or connivance and he had not acted diligently. So if these are conditions, then an independent director shall be liable. In what cases he shall be liable? It was in his knowledge, he came to know through board processes, he had consented or connived with it, and he did not act diligently, then independent director will be liable. And similar provisions are also available for non-executive director who is not a promoter of the company, who is not a KMP of the company. So for independent directors and non-executive directors, they are liable if they came to know through board processes of any act of commission or omission and they consented or connived with it and they did not act diligently, then they will be liable. Retirement of independent director by rotation not applicable. Section 149 subsection 13. The provisions of subsection 6 and 7 of section 152 in respect of retirement of directors by rotation in every annual general meeting is not applicable to appointment of independent directors. Okay. Not applicable to independent directors. Next is remuneration of independent directors, section 197, subsection 5. Now, as we already discussed, that stock options are not available for independent directors, and remuneration also, he can get sitting fees, not an issue. Sitting fees is paid for attending meetings, and in the act it is written that sitting fees can be paid for any other purpose also. So purpose can be defined for what purpose sitting fees is being paid. The maximum sitting fees is 1 lakh per meeting. He can be paid maximum 1 lakh per meeting. Independent director and women directors shall not be paid lesser than what sitting fees is being paid to other directors. So they shall not be paid anything lower than what is being paid to other directors. And maximum fees is 1 lakh per meeting. Reimbursement of expenses, if he has incurred expenses for to and fro to board meeting or any other, for attending the meetings, board meeting or other meetings, then those expenses will be reimbursed. And if he is getting any profit related commissions, then that should be approved by the members. Profit related commissions will be approved by the members, and that's it. And if in case of no profit, that will we will have to cover. In case of no profit, or in case of inadequate profits, then the schedule 5 is to be considered. Provisions relating to small shareholder director, SSD, section 151, subsection not subsection, rule 7. Section 151 read with rule 7, companies appointment and qualification of directors rules 2014. So practically I have not seen any small shareholders directors. Quickly, is it compulsory? No. small shareholder director appointment is not compulsory. A listed company may appoint. One small shareholder director may be required. And when will one small shareholder director required? When there is a notice of not less than 1000 small shareholders or one tenth of the total number of shareholders, whichever is lower. So if the company has received a notice from 1000 small shareholders or from at least one tenth of the total number of shareholders that they want to appoint a small shareholder director, then it has to be appointed, any of the lower of the two. And who is a small shareholder? A small shareholder is a shareholder holding shares of nominal value of not less than 20,000 or such other sum as may be prescribed. 20,000 rupees or such other sum as may be prescribed. So that shareholder is termed as nominal small shareholder, means holding shares of nominal value of not more than rupees 20,000. So up to 20,000, if nominal value of shareholding is up to rupees 20,000 or such higher amount or as may be prescribed, then that person qualifies to be small shareholder. If 1000 small shareholders recommend, or if one tenth of the total shareholders recommend the appointment of small shareholder director, then one small shareholder director is to be appointed by a listed company. SSD, small shareholder director, shall not be liable to retire by rotation. Perfect. Small shareholder director's tenure shall not exceed a period of 3 consecutive years, and on expiry of the tenure, he shall not be eligible for reappointment. So, a person will serve as small shareholder director only for a period of 3 years, and after that, he shall not continue. A person shall not be appointed as SSD if the person is not eligible for appointment in terms of section 154. A person shall not be appointed as small shareholder director if a person is not eligible for appointment in terms of section 164. In generally, if a person cannot be appointed as a director, then a person cannot be appointed as a small shareholder director. Small shareholder director shall vacate the office if the small shareholder director incurs any of the disqualifications specified in section 164. The office of SDD becomes vacant in pursuance of section 167. The SDD ceases to meet the criteria of independence as provided in section 149 subsection 6. So he will act like an independent director, and if he ceases to qualify to act like an independent director, then also he ceases. Maximum tenure already is 3 years. Then if his office becomes vacant under section 167, then he ceases. If he becomes disqualified, then also he ceases. Small shareholder director shall not hold the position of small shareholder director in more than two companies at the same time. So he cannot be small shareholder director in more than two companies at the same time. Moreover, the second company in which he is appointed as small shareholder director shall not be in the competing business with that of the first company. So two companies should not be competing companies, and maximum he can be director at the same time in two companies as small shareholder director. A small shareholder director shall not, for the period of 3 years from the date on which he ceases to hold office as SSD in the company he appointed in, or be associated with such company in any other capacity, either directly or indirectly. So during this period of 3 years, when he is associated with the company as small shareholder director, he will not associate with the company in any other capacity, directly or indirectly. So these were the requirements of small shareholder director. In our next video, we will start with provisions relating to additional director. Thank you. This is only for revision purpose. Thank you.